Here's an interesting case that came out yesterday. Third Appellate District of California. It's a defendant summary judgment case, and of course a summary judgment may be granted a defendant if it is shown that the plaintiff cannot establish one or more elements of his or her cause of action, or that there is a complete defense to the claim. In other words, the court throws out the case if it can't be proved. So here I put it in words so I could color things up. I'll just read you some facts. This is a long case. I'm only going to tell you about part of it. Plaintiff Jason was severely injured from a fall from a cliff above the Sacramento River in Redding. Although he cannot recall how or why he fell, he sued his two companions, Sarah and Zach, for a bunch of stuff: assault and battery and negligence, willful misconduct, and intentional infliction of emotional distress. He claims that defendants put him in peril by bringing him to the edge of a cliff when he was highly intoxicated, leading to his fall, and that they aggravated his injuries by waiting several hours to inform the authorities of the fall. So here it talks about what happened in the court below, but I want to talk more about the facts. The question on summary judgment is whether a jury reasonably could infer that Sarah put Jason in a position of peril by planning a trip to the cliff with Zach, and in cooperating with him in bringing an inebriated Jason to a place at the edge of the cliff, and in delaying the summoning of help for several hours. Okay, so she brought her drunk friend to a picnic at the edge of a cliff. Did she have a duty to help him when he got hurt? What do you think? Sarah relies on the rule that a person has no general duty to safeguard another from harm or to rescue an injured person. That rule has no application where the person has caused another to be put in a position of peril of a kind from which the injuries occurred. While there may be no duty to take care of a man who is ill or intoxicated and unable to look after himself, it is another thing entirely to eject him into the danger of a street or railroad yard, and if he is injured there will be liability. That's from a famous torts book, Prosser and Keaton. So what's the court say? We shall conclude that Jason established triable issues of material fact as to the negligence and willful misconduct of action, that on the facts tendered, a jury reasonably could infer that Sarah had acted to put an inebriated Jason in peril at the edge of a cliff. So they reversed the court below and allow it to go to the jury. So let me give you a few more facts and see what you think. On the evening of October 4th, 2008, Jason went to a party with his friend Nicholas. While there, Jason consumed alcohol and was clearly intoxicated. De La Cruz had driven Jason to the party and felt responsible for ensuring he got home safely. The friend's car had broken down as he and Jason arrived at the party, therefore he asked his roommate, Zach, to drive Jason home, and Zach agreed. In Sarah and Zach's presence, the friend told Jason that Sarah and Zach had agreed to drive him home. Sarah had known Zach for about a year prior to the night in question. They both were students at Bethel and hung out a lot. Jason left the party about 1 o'clock in the morning. Zach asked Jason if he wanted to go to the bluffs, a cliff overlooking the Sacramento River, and Jason said no. After leaving the party, they drove to Food Max, where Jason stole a fifth of rum. They then went to a second party where Jason had a couple of shots of rum. From there they drove to the bluffs to watch the sunrise. Zach parked on the side of the road and they walked to the bluffs. Zach placed a blanket near the cliff's edge for the three of them to sit on. They sat on the blanket drinking the rum Jason had stolen. They were happy and joking around until Sarah brought up the death of her brother 8 months earlier. Sarah told the others that her brother had died after falling off a bridge while intoxicated. Jason laughed, which upset Sarah, who began crying and wanted to leave. Sarah eventually calmed down and returned to the blanket. Shortly after, Jason fell. According to Sarah, Jason fell within 30 minutes of their arrival at the bluffs. Jason attempted to hang on to the edge of the cliff before losing his grip and falling. No one else was around when Jason fell. And as far as Sarah knew, there were no other witnesses to the fall besides her and Zach. Sarah heard Jason fall down the cliffside and land on the rocks below. Wow. After Jason fell, defendants grabbed the blanket and ran to the car. Once inside, Sarah told Zach, "We need to call 911. They did not do so, however, because they were afraid they would get into trouble for being intoxicated or be accused of causing Jason's fall. At the time, Sarah was 18 or 19 years old. Instead, they attempted to locate Jason by driving closer to the Sacramento River, running through the vegetation and wading into the river. When the water reached Sarah's chest and she could feel the current, she decided she could not go any further. Defendants spent approximately 1 hour attempting to locate Jason. Sarah ripped her jeans, cut her left knee, and lost her shoes that morning. According to Sarah, she did so while attempting to locate Jason. Next, the defendants drove to Whiskeytown Lake, where they discussed Jason's suicide. They returned to Redding at approximately 7 a.m. and went to Sarah's apartment complex, where they attempted to warm up in the sauna at approximately 8:30 a.m. Sarah telephoned her mother in Canada, telling her, "This guy committed suicide, he jumped." Her mother told her, "Go to the police station right away, call 911. Defendants drove to the police station and reported the incident at approximately 9:20 a.m. Jason was located 1/2 hour later. Sarah admitted that several hours passed after Jason's fall from the cliff before she reported the incident to the Redding police. Earlier that morning, between 5 a.m. and 6 a.m., Debbie Morton, who lived near the bluffs, heard a man and a woman yelling. The sounds came from the bluffs. She could not hear what they were saying, but said that they were definitely screaming and yelling at each other. Jason had no recollection of being at the bluffs, much less anything that happened there. Sarah denied touching or threatening Jason while they were there or otherwise contributing to his fall. According to Sarah, a few minutes after she shared the story about her brother, Jason stood up, faced defendants, and said something to the effect of, "I've had a hard life, and you can't die in the will of God," and stepped backwards off the cliff. So what do you think? I don't know that he said that. I don't know that he did that, but he did fall off. Something happened. He doesn't remember. And she couldn't even call 911 from then. Oh, it's so important that they can't call 911 and maybe save his life because they're afraid of getting arrested for being drunk. What do you think? I think the court made the right decision.